Hi, everybody. Hello. Thank you so much for coming out on a Friday. We're grateful you could be here. We're just thrilled to have this event on the right of assembly, which has peaked and seen increased interest in recent years with COVID and everything else that's been going on. So I'm going to introduce our two speakers and then let them take over. And I'm sure that they will give you plenty of time for student questions as we get into this. So John Inazu is the Sally D. Danforth Distinguished Professor of Law and Religion at Washington University in St. Louis. His scholarly focus is the First Amendment freedoms of speech, assembly, and religion. Inazu is the author of Liberty's Refuge, The Forgotten Freedom of Assembly from Yale University Press, and Confident Pluralism, Surviving and Thriving Through Deep Difference. And he's co-editor with Tim Keller of Uncommon Ground, Living Faithfully in a World of Difference. His weekly newsletter, Some Assembly Required, can be found on his Substack, which is johninazu.substack.com. So look him up and subscribe. The man who probably needs no introduction, at least in this building, is our own Dean Bobby Chesney. In addition to being the Dean of the Law School, he holds the James A. Baker III Chair in the Rule of Law and World Affairs. He was previously the Associate Dean for Academic Affairs and the founding director of the Robert S. Strauss Center for International Security and Law, a university-wide research unit bridging across disciplines to improve understanding of international security issues. He's also a co-founder and contributor to lawfareblog.com, the leading source for analysis, commentary, and news relating to law and national security. I could say much, much more about both of them, but I think I will turn the time over to them to jump into the right of assembly. So John, take it away. Thank you so much for being here.
Hey, thanks y'all for being here today. And I'm super excited because John and I have known each other sort of indirectly forever, sharing some common interest in this area, but this is our first time to actually meet.
Yeah.
But I've been a fan of your scholarship since you got in the academy. I've endlessly recommended your books and your writings to other people and have relied on them myself, so welcome to UT. It's a treat for us to have you here.
It's so great to be here. Thanks, Bobby. And one of Dean Chesney's very first articles was one I relied on out of the gates in my graduate work, so as you said, we've been intellectually connected for quite some time.
Well, let's. There's so much we want to talk about, but we all know it's more interesting when we engage everyone else in Q&A. So we'll talk for a while, a bit of a moderated dialogue, but be thinking about what you guys want to talk about. I thought it might be good to sort of define terms at the outset. And anyone who's ever been subjected to the podcast that me and Vladik do, you know that we can really get excited and nerd out on defining the categories and drawing the distinctions. As best exemplified by the time we debated for about 30 minutes what counts as a boy band. Like, do you have to dance? I mean, that's done. We're the Beatles. Anyways, I won't go down that rabbit hole, but here we have a definitional question that's really important. We have a whole cluster of cognate rights, I would say. Assembly, position assembly as a conceptual bucket that's different from these neighboring ones, but also connected to them.
Yeah, sure, great. And before I do, you got me thinking on the boy bands. I was reminded I've got two teenage daughters, and so last year I went with them to a Jonas Brothers concert.
Boy band, yeah.
And I wanted validation on that. I was also definitely not the target demographic of that concert. So assembly as a cognate right and assembly relative to the First Amendment. There are 5 individual rights in the First Amendment: speech, press, petition, assembly, religion. Assembly is the only one that requires more than one person to be exercised. And that was sort of one of my first observations getting into my first book was you can speak alone clearly. You could be the press today. You could just publish a blog and be a form of the press. You can petition by yourself. In at least some faiths, you can practice religion on your own. You can't assemble alone. It needs at least 2 people. And what that suggests is at the time of the founding, you have the framers of the First Amendment recognizing this way that we act in society, not just as mere individuals, but in groups of people, the togetherness of it. And that situates assembly as distinct from these other rights. The grammar of the First Amendment is, as you know, very peculiar, and there's been historical debates over whether assembly is a freestanding right or attaches to petition. I think the evidence is pretty clear that assembly and petition are different rights, but the Supreme Court has not always seen it that way. And then we might talk later about a new right added to that category, the right of association, which doesn't appear in the text of the Constitution, but has been read into it as an amalgam of these other rights, and in my view has created some additional problems around how we think about these civil liberties.
So I can really geek out on this semicolons versus commas versus, was any of this even intentional, or was it just stream of consciousness poor grammar? Let's highlight this, because it actually a lot doctrinally can hang on this. So we'll begin with the textual analysis. The assembly clause is offset by a comma from the petition clause. If you read it out loud and you don't really pause in the comma, it sounds a lot like what the drafters were accomplishing, or trying to accomplish perhaps, was protection to gather more than one person to gather in support of petitions to the government.
Right. But
the introduction of the comma, or maybe without the comma, there's an available interpretive position that says, no, this is, they use semicolons sometimes, but sometimes they don't, and they were fast and loose with these things. You have a right to a symbol that stands independent, and therefore can be a assembly for other purposes, which then requires an answer as to, well, how many other purposes?
Right.
Any other purpose? So what is the case, historically, what's the case for treating these as disjunctive rather than conjunctive?
Yeah, so before I answer that, just to add another layer of interpretive complexity, the text of the First Amendment is the right singular, the right of the people peaceably to assemble, comma, and petition for the government for a redress of grievances, which suggests textually maybe singular right applies to both assembly and petition, which would be an argument that they go together. But it turns out, as with so much of those initial provisions, there's an amalgam of recommendations coming up from the several states about the wording of the Bill of Rights, and the House of Representatives in the first Congress is trying to piece them together. The original text from at least 3 of the states was the right of the people peaceably to assemble for the common good, and then that language drops out before it's finalized. And once you're cobbling together these different provisions, the comma appears at best to be sort of residual. Someone just forgot to take it out, and then and that's probably the best we can say. But then, if the text is either ambiguous or unclear, we can look at context in other documents. And during the first Congress, as the members are debating, the question arises: do we even need an assembly clause? We've got speech and these other things, and the floor debate is, yes, we need assembly. And one of the reasons we know that is because we gathered here can all look to the example of William Penn, a Quaker arrested for an act of religious worship with other people on the streets of London. And people are talking about Penn in that moment and saying, this is why we need assembly. That has nothing to do with petitioning the government. Penn and his Quakers were acting in religious worship. And so there's a sense, even from the beginning, that assembly means more than just petitioning. And then, as you know from some of your own work, the early history of our country, particularly at the state level and lower, was all about the people claiming and enacting this right of assembly for all kinds of purposes that had nothing to do with petition.
So it's really bound up in ideas about popular sovereignty, you might say.
That's right.
Yeah, so Napoleon famously said, talking about military matters, that quantity has a quality all its own. And it's obvious what he was talking about in a military context, but there's an idea there about our role in democratic and republican self-governance, about the importance of quantity, about being with other people. And it's important to step out of the context technologically of our own times, where the idea of needing to be gathered, here we are gathered in person for the exchange of information, for some persuasion perhaps. If this is a different type of gathering, who knows what sort of action might be called forth from the conversation. But in an environment like we live in today, it's hardly even the main way ideas get propagated. In fact, most of our pathologies of the current day seem to be associated with the digital information flows that have disrupted how we communicate. But this language doesn't come from our times, it comes from their times, in which the only sort of significant communication that was taking place that wasn't in person would be the written word, the transmission of the written word. Even that was, pamphlets, tracts, and newspapers were extremely important in the transatlantic legal world that was the American and English legal realm at that time. As you were saying, there was a great deal of controversy that surrounded things we take for granted about the propriety of ordinary people getting together to discuss political matters. And that sounds weird to us perhaps, but it wasn't at all weird against a backdrop of societies that had largely tried to centralize. First of all, the whole underlying theory of political power was a centralized sovereignty theory. It wasn't popular sovereignty for most of these societies. And control over information, by that time, there had been enough time under the printing press regime to understand just how powerful information and ideas can be. And again, I say that knowing that sounds like an obvious thing. Of course information and ideas can be powerful. That was not at all obvious, I would argue, 400, 500 years ago, except to some people. And people in power understood the importance of controlling the way that information flowed. We get that today. One need only say, think about the priority that the People's Republic of China, the Communist Party of China, places on controlling information flows. Look at how in our own society, on both sides of the aisle, for different reasons, you see ever more interest in controlling the means and flows of information. Assembly, just being together in a less technologically advanced society, is itself like that. So if you can resonate to the idea that the entity that controls what can be said online has real power, then you should understand how people at this time were thinking about just the idea of people getting together to talk about things.
Yeah, that's great, and that's right. And two other observations related to power that I think continue today. One is we just know that more is often more powerful than one. The management is not going to listen to a single employee, but will listen to a labor strike. Consumer boycotts by one person usually don't go very well, but when you can aggregate them, protests with more people, even petitioning can aggregate. And so the collective nature is a form of power. And the other thing, this is certainly true back then, but also true today, these forms of power often manifest and crystallize in very informal settings. So think about the importance of the tavern or the pub during the time of the Revolution, right? It wasn't sort of in some formal congressional debate hall. It was over beers in a tavern.
Coffee houses were huge.
Coffee houses then and now. The Ferguson protesters organized principally in coffee houses. And so when we think about protecting the boundaries of assembly as a form of democratic sovereignty, as a way for people to identify and grow power, we have to be thinking about the informal spaces as much as the formal ones.
That's really interesting. You made me think about the author David Liss. I don't know if anybody's ever read any of Liss's books. He was basically like an MBA type person who really just wanted to write historical fiction. So he's written a series of books that are kind of set amidst various, like some of the historics, like the tulip craze, the Dutch East India Company stock bubble. But in his books, he really emphasizes how the coffee houses, which were brand new, coffee, as a technological matter, coffee had just begun flowing into the United Kingdom. And that is where suddenly information began to flow more freely, and it created these new points of contact. It was an assembly. It was a decentralized one, but it was an important space. And as you said earlier, in our early republic, during the Washington administration, we had serious constitutional debate and discourse about just how much authority might the government have to either criminalize or at least morally criticize and denounce private assemblies, in part because it was so visible how the country was beginning to form into political parties, that faction was in fact going to be a reality for the United States. And how was that happening? Because people were getting together. It wasn't just they were writing each other, they were getting together. Now, your examples about collective action highlight something very important about what is it that we think about assembly that warrants some regulation at the constitutional level, which is to say, creating rules that will put the framework out of reach of ordinary legislation. Is it that assemblies were media for persuasion and information flow, or is it that it was an occasion that could tip into action? It was a gathering that might tip into a riot. It was a gathering that might tip into a strike. Do you think it was more about what it could turn into, or was it just the information flows itself? Or do you think that nuance and distinction was just not really what anyone was particularly thinking about?
Yeah, I like that question a lot. I think it has to be both. So even at, predating the founding, there are laws in the books and the territories about, and the colonies about unlawful assembly. And at the time, particularly when law enforcement resources were far less sophisticated than they are today, I mean, you actually had the sheriff in the town who had the legal authority to call the posse to quell the riots, and the sense that this assembly that starts peaceably, then turns unlawful, then becomes a riot, can happen in a matter of minutes, and local law enforcement is completely overwhelmed in ways that are far less likely to happen today when you can call in the National Guard or the helicopters or whatever. So there's a sense in which that existential fear of violence erupting had to be on the table, but also, and I think this is an important point you're making, the mere fact of, we could think of it as collective identity formation, the sharing of ideas, the forming of beliefs and identities, that also mattered very much and was important. And it goes back to that lapsed or dropped language about the common good and the initial proposals of the text of the First Amendment. There was a debate in the House as to whether the language should be assembling for the common good, definite article, or their common good. And one of the interesting thoughts there is that matters, right? If it's the common good, what we all think together, then there's not much room for dissent or minority viewpoints. But if it's the people gathered, their common good, that might actually be in some tension with the broader society. And the idea that one of the reasons we protect assemblies is to allow for dissent and disagreement. It's why Madison thought that factions were a dangerous thing. There's kind of been a sanitized version of Madison in the last couple of generations that thinks Madison thought factions were great and wonderful. He thought they were dangerous and a problem to be managed because he recognized that they would foster and facilitate real disagreement, but he saw no other way around it given the society that we were and are.
That's really interesting to me. I think it really highlights that distinction between the common good and versus what we might call the subjective, the gatherer's conception. It goes right to the heart of, is this about pluralism? Is this about sustaining and enabling through legal means? Again, putting a framework on the shelf where ordinary law can't, in theory, limit it. Protection for dissent, for the sharing of unorthodox views, for heterodoxy. Or is it, if you limit it to the common good as those in power define it, then it's an illusion. It just sounds like a right, but it's not really a right. So we need to get into that. And of course, I say all this mindful that today's a terrible day in this country because of, as we turn to what's happening in Memphis, and there's going to be the release of this awful, awful video that many people are going to see and see again. It's going to be traumatizing. And I would be shocked if there is not a huge amount of assembly and protests throughout the country in all sorts of places. I think everybody thinks that is going to be the story of today. And what we're talking about here goes right to the heart of the question, setting aside circumstances in which there might be, something physical beginning to happen, but the ability to look at what amounts to the security forces in a given community, and for ordinary people to hit the streets and to loudly and disruptively announce that something is wrong here and something should be done about it. There are not that many, in human history, that was not something that happened. In the modern world, there are a lot of countries where the idea that you could do that, many of the emerging great powers, I think here again, the Communist Party of China, you certainly cannot do this very easily there. And it highlights something. A free society is a society that must have the space, no matter how disruptive and inconvenient, for some degree of this activity to take place. And it's at the heart, as you put it, of being pluralistic. We should probably talk about where is the line in a society that has embraced, or at least put into its constitution, this assembly right and tried to protect it from constraint. Where is the line between that and preserving there's a tension there with order that comes out when something turns into vandalism in a protest setting, for example, let alone something more violent than that. How does the law, or I guess I should say the doctrine in this area, how has it come to speak to this question? What are the rules?
Yeah, I'd say very imperfectly. And so one of the points you made in your last comment was the idea that a society that is going to be truly pluralistic, that is going to allow for dissent, the manifestation of discomfort or protest, is necessarily going to risk some instability and discomfort. There's no other way, right? I mean, unless you want to suppress all difference, there's going to be instability and discomfort. And so the question, the legal constitutional question, is how much breathing space are you going to give, and how much restraint must law enforcement show? And when you look back at the historical laws governing unlawful assembly, they are a fascinating blend of subjective and objective or semi-objective concerns. One of them is, an assembly is understood to be peaceful or peaceable until it disrupts the fear of an ordinary person in the community, right? So we're back to reasonable person standard in criminal law, that sort of thing. What is an ordinary person in the community? Does it matter what kind of a community you're in? If your neighbors are used to noise versus a quiet gated community, should the standard for what a peaceable assembly is differ from community to community, say in the city of Austin? That raises very complex questions and problems. And then the related question, if you're interested, look up, figure out what the statute on unlawful assembly is in Austin or in the state of Texas, and it will have, like any criminal offense, certain elements that have to be met. And in my experience in St. Louis, which has had its share of protests, law enforcement does not sufficiently recognize even what the elements are. So in Missouri, for example, an unlawful assembly requires 6 or more persons to be gathered. So if you have 5, you can't shut it down, right? I mean, if you want to regulate 5, change the statute. But the on-the-ground law enforcement is not often aware of what those material elements of the offense are. And that's a real problem when it comes to policing civil liberties. And one of the reasons is that there aren't really a lot of do-overs. So, you were mentioning likely protests in response to today's news. If law enforcement officials can effectively say, we're shutting this down, come back next week, they diminish the expressive potency of the protest. If management can say to labor, sure, you can protest us, you just have to be a mile away, right? You minimize the effectiveness of the protest. One of my favorite examples of this, I mean, it's kind of shocking, but it's a true example, is when the national political conventions meet, the DNC or the RNC, there are typically and routinely understood free speech zones is what they're called, and they are positioned with they're fenced in.
That's a euphemism.
It's incredible, right? They're positioned several miles away from the actual debates and fenced in for the safety of the protesters, far away from the cameras or anywhere else. And then people say, well, your free speech rights, your protest rights are intact because look, we're giving you safety and water over here, but it's completely diminishing the power of what the protesters want. And it goes back to that point of the desire for control or stability at the cost of the expressive power of the protester dissent.
Huge vagueness problems pervade these types of municipal ordinances. Somebody here should look up whatever I have no idea what the Austin ordinance says, but somebody look it up and we talk about it during the Q&A. I'm sure it's rife with highly subjective terms. But earlier we started off with the text and this idea that there's an available sort of tempting reading to say it looks like assembly is just for petitioning the government. And you mentioned that the Supreme Court early on, in a well-known case, took a position on this. And what position did they take, and is that still the law of the land?
Yeah, this to me is when I was doing my research on my first book, it was one of the most fascinating discoveries I came across. I think it's an 1870 decision, Presser against Illinois, where the court is looking at the Assembly Clause, and this is around sort of the Reconstruction era amendments and enforcement and some very tragically under-enforced regulations that allowed a lot of violence against African Americans in the South. The doctrinal point, though, is in that case, in that decision, the Supreme Court expressly says assembly is limited to the purposes of petition, which is just, as we already said, a misreading of the text. They've never said it again. They've never changed that position, but what that opinion did is it set in motion several decades, even several generations of legal scholarship that just assumed that to be true. And the assembly right doesn't appear much, even post-incorporation, outside of some labor and protest contexts because of this narrowing of what assembly might be. And the court has never corrected this error. I thought they were close last term in a case called Americans for Prosperity against Bonta, where there were 2 briefs to the court effectively relying on my arguments saying you need to establish assembly distinct from petition. And 3 of the justices during oral argument raised that point to counsel and said, is assembly different than petition? The answer was yes, of course they're distinct, but it didn't show up in the opinion, so I'm still waiting for indication.
Is this situation, maybe there's an explanation for this, is this like Slaughterhouse being wrong about the Privileges or Immunities Clause, but nobody cares enough to fix it because substantive due process then emerges to pick up the work? does the emergence of the non-textual but very real freedom of association doctrine pick up all the work that otherwise would have been done through the route of assembly as an independent right?
Yeah, this is certainly the argument that people would make, and complemented by one other point, which is that in the protest context, as some of you probably know, all of the protest case law has morphed from assembly to speech. So any protest case that comes before courts is typically resolved under free speech, time, place, manner analysis. And I've argued elsewhere that this really misses some of the importance of what's going on in a protest. If you rely solely on the speech dimensions, you're missing non-expressive elements of a protest, like the size of the gathering, or perhaps a gathering in silence, or where the gathering occurs, or what time of the year the gathering takes place on, all of which could be covered more effectively under assembly. But when assembly in the protest context goes to speech, and assembly in the group formation context goes to association, you're right that a lot of litigators and judges would just say, you know, maybe it was a problem, but we don't need assembly. And the argument I've tried to make is you're losing a bunch of the history and the theory around what assembly might mean, and actually how it brings together association and speech in some meaningful ways that are lost when you treat them separately. The litigation challenge, though, is that, you know, if you're a good lawyer, you want to advocate effectively on behalf of your client, you're going to make the speech argument in a protest case, you're going to make the association argument in a group autonomy case. And I've been trying to convince the litigators at least sneak in an alternative claim number 2, right? Get the court to mention it. And there's been sort of a slow uptick of this. There have been about 40 or 50 federal court decisions in the last 6 to 8 years that have at least acknowledged the assembly claim in the making. And this really saw an uptick during COVID, when there were a bunch of protest cases around COVID, and there were courts finally having to grapple with an assembly argument around a right to gather in the midst of COVID. Most of the judicial opinions that went into it in any depth spent pages and pages talking about the ambiguity of assembly, and then said, this is just too hard, we're going to turn to the right of association. So it hasn't quite worked out. But
I wonder how much you are yourself like sort of this one-man engine behind this with amicus briefs and calls to counsel and blog posts and such. If we took you out of the equation, how much of this would be there?
The good thing is it's not just me. I have an assembly of others around me now. There are probably 3 or 4 other scholars in the legal academy who have principally worked on assembly and association. They're doing good work. Tim Zick, who you probably know, Ash Bhagwat, Tabitha Abul-Haj at Drexel, and a couple in political science and sociology. There's some other folks sort of recognizing the importance of even the sociological significance of what an assembly is as distinct from an association.
I think it is a distinction. There's a Venn diagram there, but it's important to engage both halves. Emergent issues for assembly. Assume the courts are going to treat it as part of the analysis. Where do you see the most cutting edge issues? Is it with online assembly? Is there such thing as online assembly, or is that different if people aren't physically together?
Yeah, I think there has to be a connection just because of the ways that most of us live our lives more seamlessly. We don't actually have a very, bifurcated online-offline life, but in fact our relationships trickle from one to the other and conversely. And so when you think about how groups form, attachments form, sometimes our friendships start online and far away, and they morph online and otherwise somewhat differently. So I think we've got to think about the significance of online groups. I wrote an article a few years ago on this, and this is one of the points in my career where I sort of fundamentally changed my normative priors. I went into the article thinking online groups can't possibly be as significant as offline ones, just on a human sociological level. But as I started doing the research into the literature, especially in sort of Internet 1.0 sorts of movements, and the very first folks on the vanguard of that, you realize, yeah, right, exactly, and you realize, no, these are actually very significant lived communities that were deeply formative of the people who comprise them. And there are limits, of course, because when your body ages, when you die, that can't fully be covered in a purely online context because we're still bodily at the end of the day. But the online groups matter, and when you talk about sort of perspective or cutting edge issues, this is where I think some of your work really comes into play, and others who are in the security or surveillance world, because it's a lot easier for powers, private and government, to regulate and monitor the online spaces. And
That's an interesting point. We seize on that. Most of our conversation at this point was a little bit in this space of yes or no, is the assembly occurring at all? Or what time is it occurring? But not all power, so undergirding this for me, I'm sure you can all see, is concern about authoritarianism. It's always about that. It's always about what is it that if you don't get your framework right, might over time enable the human nature that we see repeatedly over time manifesting in the form of power over others, eventually enables somebody to accumulate enough government power to where those who dissent are crushed. And we have plenty of places around the world that have that now, and most of human history has actually been like that. Some exercises of power are obvious, like arresting protesters, refusing the license, not allowing it to occur. But there's a whole form of coercive power that's easy to miss that is authority knowing what's happening, observing what's happening, being able to surveil it. And so in the early 20th century, this kind of discourse would be under the heading of informants and undercover officers. In today you'd say in the mosque perhaps, or in the other days in the union, in the meeting hall. Now it may not. You don't have to get a person in there. You don't have to be able to have someone who's in the room taking on personal danger, and therefore it's even easier perhaps for the government to do that. And by the way, I'm not saying the government should never do this sort of thing. The government has all kinds of legitimate interests where under the right safeguards, oversight, and transparency, that's appropriate activity. But how much do you think there's an intersection here basically between Fourth Amendment type interests and assembly, especially as we move into the online world?
yeah, I think this intersection is only growing for all the reasons that you hinted at in that question. And even it's not just the monitoring, but it's the access to information of who the group is, or it's the exposure of relational networks that think about, there's an upside and a downside to secrecy or privacy, but there's a real important need for it, especially in protecting nascent movements or people who might be most vulnerable to different forms of power. The very first and one of the most important association cases in 1958, NAACP against Alabama, was about whether the NAACP could be forced by the state of Alabama to disclose its membership list, which then would have gone to the white citizens councils and led to private forms of violence against its members. And so the idea that even the nature of the group itself might need sometimes to be protected. And when you think about the Fourth Amendment implications of this, all of this is even broader than I think a Fourth Amendment context, but how do you try out new ideas? How do you say things in draft, right? Think about forms of executive privilege, for example, why we have these protections to allow people to work, to iterate toward the fullness of their most developed ideas. And if you circumvent that, either publicly or privately, you crush the ability to fully form ideas, to have the benefit of discourse back and forth. And I think the collapse of public and private here, which is especially apparent online, is deeply problematic, not just for enforcement reasons, but just for how we exist in the world as human beings.
So anonymity is sometimes at least a necessary condition for effective assembly, is what you're saying.
I think so, right. And even in just informal anonymity, think about your experience as students, right? Not everything can or should be performative. You should be on the spot to be coherent and cogent in your classes, but if you're thinking about an idea for the first time, it might be good just to be able to talk through it at the lunch table without having someone monitor or quote you or capture what you're saying online.
Well, yeah, look, I've got teenagers, and I think all the time about what my teenage experience was like versus theirs. They live in a recorded world. There was a practical anonymity that we enjoyed. You mentioned students being cogent and awake in the classroom. Here we are in the classroom, many students. Let's see who's awake and ask you guys to enter the conversation. You can see John and I will just geek out for hours. We'll do more later. Let's get you guys involved.
Yeah, so here in Austin, we've got the Zatari decision from the Third Court of Appeals that protected the rights of short-term rental owners under the Texas Assembly Clause. Do you see any similar application for the First Amendment Assembly Clause in the commercial context?
Oh, interesting. Yeah, I remember seeing that decision. So I think theoretically and conceptually, yes, but at some point, I would argue you just draw a normative pragmatic line. So my line has always been, I'm most concerned about what I would think of as the sphere of civil society, the non-commercial, not-for-profit host of constellation of institutions, and that's where I've sort of anchored my own normative argument. But as a theory, and I've gotten pushed back from some libertarians about this. Richard Epstein wrote a very engaged review of my first book.
I've had some engaging evaluations.
Indeed, but theory, yes, if you have a group, an assembly, whether it's commercial or non-commercial, shouldn't matter theoretically. And I do think there are different arguments to make about a commercial space. One of my own concerns is when are forms of private power so stark and significant that you actually do need to think about regulation. And I've tried to approach this through almost a monopolistic lens. It might be far different if you're the only employer or housing agency or whatever it is in a certain jurisdiction versus if you're one of many. But I've, for pragmatic reasons, tried to draw a commercial, non-commercial line, which is similar to where the Supreme Court has ended up in its association doctrine. I don't think it's perfect, and so I think it's a very fair question to ask, and a lot of more libertarian folks do ask that question, and I'm glad for the debate, but I just haven't focused there.
Google's facing a breakup lawsuit now. They may need to talk to you about this. Right. That question, I can't remember, I don't actually know the case. Do you know, was it under the state constitution?
Yeah, Texas.
Do you find that state constitutional with different text, different history, do you see some interesting doctrinal variation around the country ever on these types of
I haven't ever looked into it as carefully as I'd like to, but
there's an article idea. Article idea.
That's right. Please write that article. But there's undoubtedly variation, and some of that variation is going to reflect sort of cultural distinctiveness of certain states. When did they enter the union? When were they thinking about it around the time of assembly? To me, the peaceable modifier is always so interesting, and what does peaceability mean? How has it been interpreted by state courts and state provisions? That there's a lot of, I think, room for exploring that issue.
Yeah, there's danger. There's a lot of empowerment to authority in vague terms generally, but something like that is peaceable. Like, well, I can anticipate there might be a bad reaction. Is it sort of heckler's veto, where like, well, people hearing this is going to be there's going to be a riot because of how others are going to respond. That can really chop back the scope of the freedom. Yeah, what else is cooking?
One of the things that I think about with the right to assembly is that oftentimes it is done with the idea to contest government power, going like all the way back to the Boston Massacre, and the idea that most assemblies, especially you mentioned what's going to be happening in Memphis today and later tonight, almost certainly a lot of that is going to be a pushback against government power. So I'm curious, what do you make of the argument that placing the right to assembly, specifically to peaceably assembly, in the Constitution sort of erodes the ability of assembly to push back against government power by giving government the right to litigate what it means to assemble, what it means to do so peaceably, and sort of undercuts the ability of assembly to act as a check on government for that reason?
Yeah, I mean, I think you're right to suggest there's an inherent constraint there built into the text itself, but I think it would be, in the best circumstances, incumbent both on legislative bodies to be as not vague as possible when they're drafting these statutes, and then the other piece of this though is do the hard work of making sure that those tasked with supervising law enforcement on the ground really know the enforcement mechanisms and what those parameters are. And in Missouri, I've had some pretty extraordinary examples of engaging with law enforcement on these issues. I was on a commission for a few years that was investigating these questions, and we had subpoena power, so we brought in a bunch of chiefs from the major metropolitan areas, and I asked them, since this is my thing, I said, can you tell me, when does an assembly become unlawful? And they said, well, we support the right of peaceable assembly, we just don't allow non-peaceable ones. And that was, they kind of doubled down on the answer. I said, but you have a statute in Missouri with 5 elements about what an unlawful assembly is, so can you tell me when it becomes unlawful? And they weren't able to define that with specificity. And when there were lawsuits after Ferguson in federal court, there was similar testimony where the operational commanders just couldn't tell you what the unlawful assembly statute was. That's a problem, right? If you're actually relying on your state legislative statutory authority to stop a public gathering and you don't actually know the right elements to enforce.
That would seem to be an important consideration.
One might think, yes. Yeah.
Yes.
So So you discussed a little bit about online and in-person assembly. I would personally consider like the Me Too movement probably one of the most recent online assemblies. And I think that it was almost more powerful and instrumental in bringing some of the perpetrators to justice. How do you see online assembly become like, what do you see the future of that looking like?
Yeah, I think it's right to recognize it as an incredibly important form of power. There's a book, I'm forgetting the subtitle, but the title of the book is called New Power, and it's all about how emerging online social movements are actually manifesting an important form of power. Me Too is a good example, the Arab Spring. There are other, in some ways, following the murder of George Floyd, the ways in which nationwide protests were coordinated, all of this happens. Twitter has become very important to bringing people in physical assemblies with very little effort. I mean, think about a generation ago, if you wanted to have 10,000 people show up for a protest, it would be weeks and weeks of pre-coordination. And now there are examples of that happening effectively in very limited time because of the online world. So it's scaled the scope of power. It's also made it far more diffuse, right? So there are far more opportunities for anybody to instigate a movement or a gathering or a group, and that has its own problems. So I just think it's like any new technology, there's a huge upside, but there's also a lot to learn and kind of reflect on.
Absolutely. I mean, you made the point I wanted to make, which was that so much good can be done through these disintermediated information technologies, and so much bad can be done because technologies are always usable for whatever purpose the actual people, or apparently in the near future, ChatGPT, whatever the purpose they want to put it to. Actually, it's a case in and of itself. But one thing that follows from this is it's always instructive. Look to the most technologically adept. Where's the intersection between societies that are technologically advanced and most authoritarian? That's the Communist Party of China. Look how do they respond to this, and the way they respond is intensive governmental control over what can be said, right down to metaphors and words and common words, and then linking that pervasive throttling of what even can propagate on the network with real physical, as you say, there's always a body at the end of the day, and that body can be sent to jail, and so can its relatives. That's where coercive power is at its most extreme, and these technologies to some extent enable this. And I mention this just because in our country we're having this ongoing dialogue about what is the role of government in intervening because somebody didn't like what Twitter did before, or no, they don't like what they're doing now. Maybe we should just let the government decide these things. I say, be careful.
Your track record is not very good.
You are gonna regret it, no matter how appealing it seems right at this moment because of the particular alignment of one's politics versus what you think some privately owned communication mechanism is doing. Whatever it is, later on when your worst enemy's in power, you're gonna regret it.
No, that's right. Yeah, one other observation too about the online sort of upside downside is just think this is generalizable to any group. The human desire to find like-minded people, right? What C.S. Lewis described as friendship, where you see someone, you say, "Oh, you too? Like, you are like me." And online networking and relationality allows us to scale that in all kinds of ways. So I'm just making this up now. I'm a half Japanese man who's allergic to soy, right? True story. But 100 years ago, I might have thought I'm the only one. But now, like, I could actually probably go online and find a community of other, Japanese people allergic to soy, and we could have some solidarity. And that's a bit of a silly example, but there are ways, very powerful ways, in which people who otherwise felt extremely isolated have found similarly situated or like-minded people online, built that solidarity. But we can all think of also very quickly very awful examples of the same kinds of solidarity forming. And so it's a technology that in itself is kind of neutral, and in the ways in which we experience it, regulate it, don't regulate it, are going to have consequences.
Yes?
Kind of building off the question about the digital commons, do you think the emergence of that digital space of virtual assembly, essentially, do you think that undercuts a societal need or a felt need for the protection for the right to assembly?
Well, I would say, just going back to an earlier point, I think because of the ways in which we live our lives both online and offline, you're never going to be able to confine it to one or the other. So I think almost as a matter of logic, you've got to have protections for both, or you're going to have protections for neither. I do think one of the concerns I have about the growing focus of our online interactions is the ways, and this gets to something you were hinting at earlier with sort of private power, the ways in which the public forum of old is now largely operated as I've called it the private public forum. It's a space or an online area that is no longer, the classic public forum was a demand by the people to the government to say, you must provide, protect, and pay for a space where we as citizens can come together on our own terms and say what we want. The city park, the city street, this is the public forum. And then in the 80s and 90s, you had more and more of those bought up by private developers, and suddenly the First Amendment questions change, right? Do I have the same speech or protest rights in a shopping mall privately owned that I once had in the city park? Now we've jumped online, and most of our discourse is happening within platforms operated by private companies, and which raise different questions than the First Amendment questions. And so I do have a worry about how much of our, especially our, if we can call it discourse, our online interactions are now happening outside of these classically protected First Amendment spaces.
Can you talk some more about that point? I mean, we're seeing coming up to the Fifth Circuit, to the 11th Circuit, these cases essentially, but with regard to the free speech issue, supposedly get a Supreme Court decision either this term or next, resolving those. Do you think that just the next field of play for this issue to be litigated is in the association or assembly space vis-a-vis these online private fora? I guess the question most specifically is, what is litigation of this issue going to look like in the future with these private online spaces?
Yeah, well, I'm always hoping that it'll turn to assembly. I haven't given up hope yet. But no, I think it's actually, one of the comments that Bobby you made a minute ago was, be careful what you ask for, right? The over-regulation of these private entities has its own set of problems and potential problems. So it's unclear to me there are going to be plenty of litigators who are going to be bringing these claims in the coming years. So there's going to be, I think, inevitably going to be a lot of case law emerging around these very questions at the intersection of speech, also privacy, and assembly and association. Now, how they turn out or where it goes, I'm less sure about. But I do think the really fascinating sort of social point about all of this is because we're in largely unregulated spaces, we're kind of reaping the fruits of our own desires in some ways, right? What's coming out is the algorithms are showing us what we want, and it doesn't look very pretty. So the alternative is to try to regulate the algorithms, which raises dangers, or let us keep falling into our own vices, which has its own set of dangers when you think about the future of public discourse or trust in elections. I mean, think about the next presidential election and the advent of deep fakes. You've written about this. There is a, not to get all doomsday here, but there is a scenario where within a period of a very short number of hours, we could have an extremely chaotic constitutional moment driven by the amalgam of the kinds of questions we're talking about, right?
Yikes. Talking about algorithms and the role that recommendation algorithms, whether you perceive it as a user to be a recommendation algorithm or not, because some platforms vary in how much you see that. If you've been on Twitter lately, now it's like, do you get to follow who you follow or who they for you send to you? Sometimes you can see when it's what the company, what the algorithm is recommending for you. Sometimes you can't. Is it a mirror? Are we looking at ourselves and seeing ourselves? And that's bad, if so, because it's pretty bad. I don't think it is, or at least I think the algorithm as a mirror, it's a funhouse mirror.
Oh, interesting.
That is not meant to be an accurate reflection. It is meant to send something back to you based on you, but distorted and caricatured, because the goal is to keep your eyeballs on that app, and that only works if they can scare you, titillate you in some way to get to play to just about anything but your better angels. And I think that feature of it does suggest something different from, say, the traditional public forum, where the park's the park, and it doesn't really, whatever's going on there isn't in any way being inflected by the owner. I mean, maybe I'm sure we can come up with some examples, but nothing like the pervasiveness of this subtle funhouse mirror effect that pretty much each of the major platform apps in some sense reflect. I mean, we've all had the experience. You do a search for something because you have to buy a present for another person, and you know they're into something. It's not your thing, but you do a search for that. Now for the next 2 years, all your ads, they all think that, you know, Transformers, that's your bag, or whatever it is. I get a lot of guitar apps across all my platforms, and that's great because I'm happy to see them, but I realize like, I don't even want to search for, I don't even want to buy people presents now.
Yeah, no, that's right. I think I really like the funhouse mirror metaphor here, and another way in which our online interactions are like the funhouse mirror is they are so underrepresentative of most people's lives in the majority of the country. So take Twitter, for example. What a small percentage of the country is actually on Twitter or cares about Twitter, and then what a small percentage of Twitter is actually driving most of the content. And so when you have sort of, post-Trump in 2016, where a bunch of Twitter folks said, I didn't know any Trump voters. How's that possible? Because Twitter, the funhouse mirror was American society was 6% of Twitter users who were 10% of the country, who then felt like all of America, right? This is a common sort of echo chamber problem, and it's very difficult to get out of it when you're felt reality. I mean, I was thinking also of after Musk takes over Twitter, a lot of Twitter types were saying, I'm out, I'm leaving Twitter and going to another platform, and it turns out nobody cares because nobody, they weren't actually, I mean, most people are on Twitter to follow the boy bands, right, or sports, and so we're just not as important as we think, but we distort ourselves to think that the discourse revolves around our peer groups, and that itself is a funhouse.
You're saying the migration to Mastodon ain't happening?
I don't think it worked.
Yes.
I would quibble a little bit with your claim that we didn't see sort of inflection of the values of where the assemblies were hosted in the past. I'm thinking a lot about when you go to meet at X place, if you're meeting in a church basement versus if you're meeting in a community center versus if you're meeting in a park, seems to me to have certain value inflection as a result of that. And I'm conceptualizing it more as when you meet online, there's not necessarily social costs to that, because in many ways you aren't being held accountable face to face like you have been at every other point in our history. You can make anonymous accounts, you can make bot accounts that artificially inflate and twist the discourse as a result. So I'm curious if it is a function of the space of Twitter, or is a function of the internet as a place that protects your anonymity, not just from people outside of your group, but with people inside your group that you are nominally in discourse with. They don't know that you are who you say you are.
Yeah, we could have a whole other discussion about that piece of it. It's a great question. I think the disembodied plus anonymous nature of some of these platforms, again, has both upsides and downsides. So as you were talking, I was thinking about telehealth, for example, right, or mental health counseling that has moved online in the pandemic. That is a great thing for a lot of people. It lowers the bar to access. It makes it more accessible and efficient, and yet also the possibility of anonymity allows for, especially when you can take your actual identity out of the equation, it allows for all kinds of
Trolling is rooted in this.
Yeah.
I firmly believe that trolling in all its manifestations is the same thing as road rage. There's a distance and anonymity that enables you to act in a way that none of us would act in this room face to face. There's a loss of accountability that turns out to provide, for some people, a lot of their self-regulation is whether they think they'll be accountable for what they say.
Because this is one of the reasons why I think the collapse of face-to-face academic conferences is a real loss for people like us. Because when you're forced to show up and have a meal with someone who you might be arguing with on Twitter in 2 weeks, it's going to affect your relational dynamics, right?
For sure.
Everyone, please join me in thanking Professor Inazu. Thank you all so much. That was wonderful. For future events on February 8th, we have Asma Udin coming from, she's a law professor at Catholic University. She's going to be joined by Emma Green of The New Yorker, talking about religious freedom for all and how that intersects with the Muslim experience in the United States. That'll be at the Student Union. Hope you can see you there.